Hi, I'm Dana Middleton. Welcome to this training course on HIPAA privacy and security.
And I'm Enrique Cerna. Today, Dana and I are going to discuss the information you need to know about the new HIPAA privacy and security regulations. You'll need to understand these new regulations and know how they apply to you and your organization.
As healthcare providers, our patients trust us to keep their health and billing information confidential. This means we must protect their information from anyone who doesn't have reason to know it, even our own employees. The individuals who rely on us for care expect that their information will be kept secure and protected.
This may sound easy, but unless you know exactly what the law requires, you could get yourself and your organization in real trouble.
So, what kind of information does the HIPAA law cover? Who must comply with this law? What information is considered protected, and when does the law take effect?
We'll answer these questions and give you some real-life examples and how you need to handle information protected under the HIPAA regulations.
As you may know, HIPAA stands for Health Insurance Portability and Accountability Act. This law makes broad, sweeping changes to the healthcare industry. Several provisions of the law have already been put into place. These include a guarantee that someone leaving a job will not lose certain health care coverage, and it establishes minimum standards for small group insurance.
The U.S. Congress passed the HIPAA Act back in 1996. Even though the law was passed several years ago, compliance requirements for some parts of the law remain unfinished business.
The HIPAA privacy regulations are in effect now. Enforcement of privacy compliance will take effect in April of 2003. This has major implications for all of us involved in the healthcare industry.
You've probably been aware of privacy issues for a while. You may feel like you know quite a bit about privacy, and chances are you do. You also know it's getting harder to protect the confidentiality of health information these days. Computer systems and networks are becoming more complex and contain more private information than ever before. Additionally, the number and types of business relationships we have in the healthcare industry can be complex and at times confusing. As part of our business, we routinely have to share private health information with those inside and outside of our organizations. It's easy to see how this information is at risk of being accessed by people who have no need or right to see it.
With HIPAA, protecting private health information is now the law. The implications of non-compliance can have serious ramifications, both for you personally and for your organization.
For instance, not complying with the HIPAA law could mean large lawsuits against your organization, fines of up to $25,000 for incidental violations, fines of up to $250,000 for intentional violations, possible loss of your job, and even prison time for violations with criminal intent.
As you can see, it pays to know exactly what you're doing when it comes to following the HIPAA privacy regulations. Let's take a look at a true example of what can happen if you aren't careful. Recently, the Medical Records Department at a large nationally known hospital received a request from a person we'll call John Doe. John requested a copy of his personal health records. The hospital thought they were complying with a routine request for patient records. The request was in writing, it gave a return address, and it had a signature. Everything seemed to be in order. Unfortunately, the requester wasn't John, but an imposter. Neither the return address nor the signature was valid. The hospital didn't attempt to verify the information contained in the request. The imposter received the full medical records from the hospital. Included in these records were descriptions of treatments for a drug problem John experienced on return from the Vietnam War. The false requester then forwarded a summary of those private health records to various family members, friends, and clients of John Doe. As you can imagine, revealing these private records caused major damage to his reputation, his business, and his standing in the community. The woman who made the falsified request for the medical records was a disgruntled former friend and business partner. She was eventually caught and is now serving time in prison. John, the real patient, then filed a $12 million lawsuit against the hospital, whose main defense was that it acted in good faith.
In order to fully understand and comply with the HIPAA law, there are some terms and concepts that we have to be familiar with. First, we will discuss how the HIPAA law defines both privacy and security. Next, we will look at how the HIPAA law defines a covered entity. We'll discuss what kinds of organizations are covered under HIPAA. Finally, we'll discuss the privacy and security considerations of working with business associates. Privacy refers to the protection of an individual's healthcare data. Privacy defines which data is protected, how data can be used, and how data is to be disclosed. Protected information is any information that identifies a person and is related to their health or payment for care. Some examples of protected data include a name and address, phone numbers, a social security number, any healthcare specifics such as a treatment or diagnosis, and any payment information such as account status or the timeliness of payment. All organizations covered under HIPAA are required to give their patients or customers details on what the organization will and will not do with their health information. All organizations covered under HIPAA agree not to disclose health information for reasons other than treatment, payment, or other routine healthcare-related business, unless a written authorization is on file. Security refers to the systems in place to guard the integrity and accessibility of the physical data. Security protects data integrity, confidentiality, and availability by using administrative procedures, physical safeguards, and technical security services and mechanisms. You must manage both privacy and security to ensure the confidentiality of personal health information is maintained. Organizations that are subject to the HIPAA law are called covered entities. Some common HIPAA-covered entities include healthcare providers. This includes everything from large hospital chains to small health clinics. Also included are labs, pharmacies, doctors, nurses, dentists, nursing homes, psychotherapists, and others. Health plans or insurers, including HMOs. These are generally organizations involved in administering and paying health claims. Healthcare clearinghouses. These are groups that process information for other organizations, including billing services and repricing companies. All of these organizations are HIPAA-covered entities and are required to comply with the HIPAA privacy statutes. Everyone in the system has to work together to keep health information private. We in the healthcare industry sometimes let others outside of our own organization see or use health information as part of our routine operations. Organizations that provide dictation, legal, consulting, financial, or other such services may have access to protected healthcare information. Other organizations, such as accreditation agencies, also may access protected information. These are our business associates. Our business associates are acting on our behalf. We have to make certain that they use and handle the healthcare information given to them in the appropriate manner. Although our business associates are not directly covered under HIPAA law, we are, and we are required to have special contracts with them regarding the use and handling of private healthcare information. If you think one of your business associates is not respecting this privacy, you must report your concerns to your supervisor or your privacy officer.
You may frequently encounter information about the health of individuals. It's important to protect the privacy of this health information. Let's discuss what is meant by protected health information, or PHI, so that you can recognize it when it's seen or heard. Even if you don't work with protected health information in your daily job activities, it's all around you. You need to be very aware of keeping PHI safe so it doesn't get out where it doesn't belong. Here's a real example of how protected health information got into the wrong hands and resulted in trouble for the healthcare provider. Julie and Rob were looking forward to the birth of their first child. Anita, who worked in the radiology department of the hospital, was looking forward to the end of her shift. She printed out the day's dictations to the main departmental printer. When she picked up the forms, she accidentally left one report on the printer. It was still there when she left for the day. That evening, a co-worker from the billing department was collecting some reports from that same printer when she came across the report Anita missed. She was excited when she read the ultrasound report of her next-door neighbors, Julie and Rob. Assuming Julie and Rob must be thrilled, the next day when Marilyn saw them, she immediately congratulated them on their little girl. Julie and Rob were first stunned, then angry. They had decided to wait until the baby's birth to find out if they were having a boy or a girl. While everyone involved apologized to the couple, both Julie and Rob felt their privacy had been violated, and they filed an official complaint. This is just one example of how carelessness or ignorance of protected health information can lead to real problems for everyone involved. Careless violations such as this can happen in every type and size of healthcare organization.
Employees may have questions that need to be answered and understood. For example,
I'm not sure I totally understand protected health information. I have a few questions I need to have answered. For example, what is PHI? What is individually identifiable? What form does PHI take? What is not considered PHI?
these are all great questions. Let's begin with what is PHI? PHI, or Protected Health Information, refers to individually identifiable health information that is transmitted or maintained in any form or medium by a HIPAA-covered entity. To be protected, health information has to be individually identifiable. In other words, the information may be used to determine the identity of an individual. Individually identifiable health information can relate to the physical or mental health of an individual, or information regarding payment for an individual's health services, and information that has something identifiable, like a name or number that might be used to identify the individual. Just the fact that someone goes to visit a doctor or is in the hospital is identifiable health information about that person and must be protected. Protected health information can take many forms. Some examples that PHI can take include paper copies, patient files, telephone calls, email and voicemail, verbal communications, fax transmissions, information transmitted over the internet or company intranet, and even sticky notes or other forms of temporary communication. Patient information in any form can be considered PHI. HIPAA does not consider health information contained in educational records to be PHI. This information is covered by the Family Educational Right and Privacy Act. Also, information contained in a covered entity's records in its capacity as an employer is not considered PHI. So protected health information, or PHI, is anything you see or hear that lets you know about the health of a specific individual. Even the fact that an individual is a patient of ours or pays us for services is protected health information. Let's take a look at another example of how protected health information can sometimes be compromised, even when we think that information is protected.
Hey, Gloria, you want to see me?
Yeah, hi, Randy. Come on in, have a seat. I need to talk to you about Mrs. White. I received a call from her husband today saying you gave out some information about his wife.
Oh, yeah, but I didn't use her name. Mrs. White was a patient at our OBGYN clinic. She was really uncomfortable with her twins. She couldn't get any sleep, so she got one of those comfortronic beds, you know, the kind that adjusts to the shape of your body. It was the only way she could sleep. So I did contact the Comfortronics people because they're one of our vendors, and I thought they might want to know, so they might be able to help out other pregnant women.
Randy, you do understand that you need to get a signed authorization to use her PHI?
Well, I didn't use her name.
Well, apparently you used the name and address from the email you got from Comfortronics, but you left in her clinic number, which is the same as her Social Security number.
Oh. That's not good.
It's a violation of protected health information, and unfortunately, Mr. White has filed a formal complaint with my office.
We need to be very careful with protected health information. People expect that we will protect their information from anyone who doesn't need to know it, even our own employees. If you're in doubt or something doesn't feel right, ask. Feel free to go to your supervisor or privacy officer for help. Remember, don't snoop, don't gossip. Keep your voice down and be aware of your surroundings. And most importantly, respect people's health information.
All organizations covered under HIPAA are required to give their patients or customers a notice of privacy practices when they first encounter them. This notice provides details on what the organization will and will not do with their health information according to the HIPAA law. It tells individuals that their health information will be used very carefully and will not be disclosed to outside parties other than those directly involved in treatment or payment without written authorization from them. Finally, it tells individuals about their new rights to access their own health information and receive confidential communications. Organizations that deliver health care directly will ask people to sign this Notice of Privacy Practices to confirm that they have received and understand these rights. Organizations covered under HIPAA agree not to use individuals' protected health information for reasons other than treatment, payment, or other routine health care related business, unless a written authorization is on file. An authorization is required for situations outside of the normal course of healthcare-related business, like marketing or research. For example, to use an individual's information for marketing purposes, an organization would need to have a signed authorization form from the person. The authorization must be specific to the particular situation for which it is being requested and have a limited duration. HIPAA gives several specific new rights to people concerning their health information. People can request to read and obtain copies of their medical records, their PHI, at any time. There are times when the person's requests can be denied. These include psychotherapy notes, information gathered for a court of law, and when releasing the information would cause harm to the individual or another person. A person who feels his or her PHI contains an error may request an amendment be entered into the record to correct the error. Individuals also have the right to an accounting of all disclosures of their PHI for reasons other than routine payment, treatment, and healthcare business operations. All organizations covered under HIPAA are required to keep track of all such disclosures. A disclosure report should include the dates, the names, the specific information disclosed, and an explanation. Individuals also have the right to file a complaint if they feel their confidentiality has been breached or their PHI has been handled contrary to HIPAA regulations. A HIPAA-covered entity must have a person identified to handle complaints, along with procedures for dealing with those complaints. Individuals can request that confidential communication be received at a location other than their home address. For example, a woman could request that her pregnancy test be relayed to her at her business address. People can request special handling procedures for their PHI. For example, a person could request that his PHI never be shared with any outside party or organization. However, even if the individual requests special handling of PHI, the law does not require the healthcare organization to agree with the request.
Medical records and claim information have traditionally been recorded on paper and stored in filing cabinets. With the introduction of computer systems, health information has become harder to protect and is potentially accessible by many more people. We must work hard to keep our information systems secure and protect an individual's PHI. HIPAA regulations apply to both those organizations that maintain paper records as well as those that have computerized their record keeping. Let's take a look at a case study in which a major violation of privacy occurred. In one of the most damaging violations of privacy over the Internet, detailed psychological records containing the innermost secrets of at least 62 children and teenagers were accidentally posted on a university website. The 400 pages of documents described patient visits and offered diagnoses by therapists on a variety of conditions, including mental retardation, depression, schizophrenia, and other serious conditions. The information posted included names, dates of birth, home addresses, and detailed results of psychological testing. These electronic medical records, once placed on the internet, exposed the material to a vast audience that was never intended to see them. They were removed after a local newspaper reported the story. But by that time, the damage had been done. The university now had to deal with a serious breach of private information in a very public setting. In a similar case, a large pharmaceutical manufacturer inadvertently divulged the names and addresses of 600 psychiatric patients in a bulk email. These cases point out how careful we must be with private data stored in computer files and on computer systems. Today, most health information is stored on computers. Special precautions should be taken to ensure that electronic information is not accessible to people who are not authorized to see it, is not damaged or changed maliciously or by mistake, is readily accessible to organizations who need it quickly while still maintaining security. Let's look at some of the key policies for securing computerized records. Regarding data access, don't snoop. Never try to access data you are not authorized to use. Report all breaches of security to your supervisor or security officer. Log off your computer before leaving it, and do not use anyone else's computer unless you are authorized to do so. Do not share passwords or leave them where others can see them. Do not alter your computer's hardware or software unless you are authorized to do so. Never leave an individual's health or financial information on your computer screen or openly accessible in your workplace where it could be viewed or retrieved by others. Never create, change, or delete records unless you have specific authority to do so. There are several security issues to keep in mind in regard to paper records. Only authorized personnel should have access to the location where PHI is stored. PHI on paper should never be left unattended in a non-secure area. Visitors should obtain clearance upon entry and be escorted when in areas where patient information is stored or accessible. And keys, key cards, or tokens should be securely stored. To summarize, you must be careful with your computer systems and physical data. You can take many common sense steps to protect sensitive information. Lock all file cabinets that contain PHI. Don't leave information on the printer or fax machine. If the printer or fax machine receives PHI, keep this equipment away from common areas. Don't put your passwords on a sticky note near your computer, and never forward emails that contain PHI. Your organization will have policies and procedures for how to handle PHI in faxes, email, and internet communications. Be sure you know them. Remember, be careful with your computer systems and physical data.
All healthcare organizations must have a privacy officer or a specific person responsible for HIPAA policies and procedures. This person makes sure the health information of individuals is kept private and is in charge of the organization's policies and procedures to protect privacy. You are expected to report any concerns you have about the handling of protected health information. However, it is your duty to immediately report any violations to HIPAA policies and procedures. If you don't want to report your concerns to your supervisor, you should go straight to the privacy officer. Let's take a moment and see how to handle a breach of security of an individual's records. While walking through your facility, you find a file on the break room table containing sensitive health information. There is no one in the room at the time. You are tempted to close and remove the file before leaving the room, as you know this is a breach of privacy. Instead, you remember that in training, you were instructed to immediately contact your supervisor to report a situation like this. You contact your supervisor by the phone in the break room and report the situation and ask what you should do next. Your supervisor commends you for your alertness and asks you to remain in the break room until someone is sent to retrieve the file. Your organization wants you to report any problems you see. A non-retaliation policy means that you will not get into any trouble for reporting these violations.
I have a concern.
Whistleblowers are welcome and will not be punished in any way. It's the law, and it's a good business practice. It's your responsibility to know your organization's specific policies and procedures as they relate to HIPAA privacy regulations. It's your responsibility to report it when they are not observed. Your organization may discipline anyone who violates your HIPAA policies and procedures. In our industry, protected health information is easily available to most employees. You expect your healthcare information to be kept private, so do others. It is everyone's responsibility to make sure an individual's PHI remains private. Hello, I'm Enrique Cerna. Welcome to this training course on managing protected health information.
And I'm Dana Middleton. Today, Enrique and I are going to familiarize you with the basics of handling protected health information, or PHI, according to the HIPAA regulations, so that you can be in compliance while doing your job. We'll watch Tracy, an admitting representative, work with PHI issues as she does her job. We'll also review several scenarios to see why managing PHI is so important to the organization. Let's learn more about managing PHI.
In the introduction to HIPAA privacy and security training, we discuss how to recognize and take steps to safeguard protected health information. In this course, we'll discuss working with PHI in more detail. We'll review how to determine if health information is individually identifiable and learn how to de-identify information so it is no longer considered protected. Uses and disclosures in day-to-day business. Verifying the identity of someone who requests health information. Minimum necessary disclosure. Our duty to control the damage of an unauthorized release of health information. The basic concept of an authorization, when you need one and sometimes when you don't. Only health information that can be used to identify an individual is subject to the HIPAA privacy rule. Health information that could not be reasonably used to identify an individual is not subject to the privacy rule and can be disclosed. Health information can be de-identified by removing all of the following identifiers regarding the individual, relatives, employers, or household members. Names, all elements of dates, telephone numbers, fax numbers, electronic mail addresses, social security numbers, medical record numbers, certificate license numbers, health plan beneficiary numbers, account numbers, certificate license numbers, vehicle identifiers, device identifiers and serial numbers, Internet Protocol address number, biometric identifiers, full-face photographic images, any other unique identifying number, characteristic, or code. The HIPAA law, for the first time, spells out how we can use an individual's protected health information, PHI. The two basic ways health information is used are for routine operations and outside disclosures. These are treated very differently under HIPAA. Let's look more closely at these two categories. Routine operations, the normal day-to-day activities of the organization, include the health care of a patient, payment for care or health care operations. This information is used to enable treatment and services and does not require written authorization. Outside disclosures include information not required for treatment, payment, or healthcare operations, or information outside routine provider, insurer communication. Routine operations refer to information used for treatment, payment, and healthcare operations. We are allowed to use protected information in the normal course of doing healthcare-related business. For example, when you discuss a case with a physician over the phone to authorize a special procedure, you can do so because you are discussing routine issues of treatment or payment. The insurer and the provider employees carefully use PHI internally and with each other to solve daily problems. Outside disclosures require a specific authorization for uses of health information outside of the normal course of healthcare-related business. These include activities such as marketing or research. For example, to send patient information to a pharmaceutical company, you would be making an outside disclosure. Most outside disclosures require a written authorization from the patient.
As we discussed, some uses of information fall under routine operations and others under outside disclosures. Can you identify the differences between the two? Any communication that is outside a routine provider-insurer exchange? Yes, that belongs under outside disclosures. Information used for the health care of a patient. That would fall under routine operations. Information used for payment of a claim. This is a routine operation. And information for uses other than treatment, payment, and healthcare operations. This would be an outside disclosure. Remember, the use of protected health information does not require a written authorization if it's a routine operation. If you need to disclose PHI for reasons outside of the normal course of healthcare-related business, you would need specific authorization to do so.
The HIPAA law is not trying to stop us from doing our daily work with health information. This daily work frequently includes back and forth communication of PHI between health plans and providers. The insurer and the provider organization are free to use private health information in day-to-day business. Providers and insurers work together, routinely sharing PHI for treatment, payment, and operations. We call this TPO. Individuals have been notified that we will use their information in day-to-day business, but we have to be careful with people's health information. The two key principles of being careful with health information are verifying the requester and disclosing only minimum necessary information. You have to confirm that the requester is entitled to receive the information before it is sent out. There are many ways to verify that a person is who they say they are. For example, you can identify an individual by their name and address, their social security number, their date of birth. A doctor's office can be identified by name and tax ID number. A police officer can be identified by a badge. Supplying the minimum necessary information means that you only tell the requester what he or she needs to know. You should not offer additional information. Also, you should not ask for nor look at information you don't need to know. For example, a discussion about the payment status of a bill for depression treatment generally needs only to reference the bill number, claim number, date of service, and payment status. The diagnosis is usually not needed and should neither be asked for nor disclosed.
Let's look in on Tracy, an admitting representative, taking a call from a fellow employee.
City Health Center, this is Tracy. How can I help you?
Hi, this is Frank Rubens over in security. There's a van parked right outside the ER door. Has ER admitted somebody named Robertson recently?
Let's look at some right and wrong ways to respond to Frank's request.
Yes, it looks like we have a Steve Robertson in ER. He was just checked in with a drug overdose.
There's a problem here. Tracy has failed to identify the requester and has provided more than the minimum necessary information. In this case, the requester is a person who is not entitled to the information just given. Let's see another option from Tracy.
I can check, but first I need some more information. What's your employee ID number?
Yes, Tracy needs to verify the identity of the requester, who may either be Frank Rubin or someone posing as Frank in order to obtain information to which he is not entitled. Tracy has asked for the correct identifier used at her organization. You need to know how your organization will verify a requester. Let's see one more option.
Yes, a patient named Robertson was admitted to the emergency department.
This is correct minimum disclosure. This is all the information to which Frank is entitled. It's not necessary to say what the service is for. However, if Tracy had offered this information before she verified Frank's identity, she would have been in error.
Let's watch Tracy take another call.
Hi, this is Tracy. How can I help you?
Hi, I'm from American Labs. I want to see if you had a clinic visit for herpes for a patient named David Burns.
Let's look at some right and wrong ways to respond to this request.
Yes, he does have a clinic visit for that. It's dated for the 1st of the month.
Wait a minute. I don't think that woman is from American Labs. I don't know who she is, but unless she is from American Labs, she doesn't have any right to that information. Why didn't Tracy check to see who she was? Let's see another response.
I first need to get your company's tax ID number. Can you provide that to me, please?
Good job. Tracy needs to verify the caller before she does anything else. Requiring the caller's tax ID number is how Tracy's organization verifies who the caller is. Once she has verified the caller, then she can give out the claim information. Let's go on to the final option.
Okay, I verified your ID number. We show a clinic visit for herpes on the 1st of this month.
What? Why would she be giving out that information? After Tracy has proven that this woman is from American Labs, all she is allowed to tell her is that there is a clinic visit, not what it's for.
To verify the requester, we must verify both the identity and the authority of the person requesting information. There are many ways to verify that people are who they say they are. For example, you can ask for a birth date or a social security number. Ask for the mother's maiden name or other unique information. Check a physical signature against a known one on file. Or make a call back to a known number. Your organization has procedures to follow for verifying a person's identity. You should follow these procedures whenever you need to verify the identity of a requester. Once you know who the requester is, be sure he or she has the right to access this information. Routine requests from employees that you know in your own organization are usually okay. Unusual requests from individuals you don't know are risky. Be sure they have the right to receive PHI, or if in doubt, ask your supervisor. You must verify both the identity and the authority of the requester to be sure you can disclose protected health information.
Even after you have verified the requester, you must disclose minimum necessary information to take care of PHI. Perhaps you already know the requester. Perhaps you have made a very simple check like a birth date. Perhaps you have made a detailed check with a callback. Perhaps you trust the authority of a coworker or have seen an authorizing document. You still need to reduce the risk by giving out only the minimum necessary information. Your coworkers will usually ask for only what they need. Unusual requests coming from individuals you don't know are risky. Even if you verify the requesters, limit the information you give out. No more than exactly what they are authorized to receive. You must both verify the requester and give minimum necessary information to safeguard PHI.
We must be careful with people's health information. People expect that we will protect their information from anyone who does not need to know it, even our own employees. Your organization has specific policies and procedures to help you decide how to make or request disclosures in your daily work. Be sure you know the policies that apply to you. If you're in doubt or something doesn't feel right, ask. You must go to your supervisor or privacy officer for help.
Your organization is committed to making sure that individuals are not harmed by the unauthorized disclosure of their protected health information. What should you do if you learn that private health information has been released outside of routine business functions without authorization? Tell your supervisor or the privacy officer. We have a duty to mitigate the effects of unauthorized release. Let's view a conversation between Tracy and Randy. As we view the discussion, think about what you would do if you heard this story from Randy.
Hey, Tracy.
Hey, Randy, how you doing?
Good.
Hey, I need to talk to you for a second.
Okay.
You know, Randy, I'm just not sure that you should have told your old high school principal about Mrs. Elliott's hospital stay. I know she's been a teacher there a long time, but she expects us to keep her health information private. We need an authorization from her before you can release any information such as this.
Okay, I'll have to fix that.
Unfortunately, I only told her principal she'd been in the hospital a few days. I didn't talk about a specific treatment or illness.
Randy, even the fact that a person is receiving health care or that they're insured by a particular company is protected health information. You breached this person's privacy.
I'm sorry. I'll try to be more careful about PHI in the future.
Great, I appreciate that.
Here's where you should involve the privacy officer. They have a duty to control the damage of this type of unauthorized disclosure. Don't try to control the damage yourself. Just call your supervisor or your privacy officer right away and let them know about your concerns.
What would you do if you heard this story from Randy?
Hi, Gloria.
Oh, hi, Tracy.
Hey, I'm a little worried. I think we may have an unauthorized disclosure of PHI to deal with. Let me tell you what happened.
Oh, okay. I'll call the principal and Mrs. Elliott right away, and I'll warn her. Oh, we'll not let this get any further than it already has. Thank you, Tracy. Thank you for telling me.
At this point, the privacy officer takes over and goes into damage control on the situation, attempting to minimize any further harm to the organization or further release of protected information. When people use our services, they expect that we will only use their protected health information as necessary to provide and pay for health care. They do not expect us to use this information for any commercial purposes, such as marketing research, donation requests, or product sales. If we want to give health information to outsiders for purposes like these, we must obtain a very specific written authorization. Here are 3 examples where authorization is required before releasing an individual's information. Note that these are not routine disclosures required to care for a person, pay for that care, or authorize payment for treatments. Those types of routine disclosures do not require authorization. A person signs an authorization form releasing PHI to a life and casualty insurance company in order to obtain disability coverage. A man signs an authorization to have his PHI released to a pharmaceutical company planning a drug trial. A woman signs an authorization to have her pregnancy status released to a business that markets infant care products.
While the authorization rule covers most situations, HIPAA does allow exceptions for the good of the general population. These 3 exceptions show situations in which authorization is not required prior to releasing the person's information. HIPAA recognizes that there are certain situations where the individual's PHI is needed. For example, in public health activities, such as tracking and notification of disease outbreaks. For example, hepatitis or measles outbreaks. Infection control. Statistics related to dangerous problems with drugs or medical equipment. HIPAA recognizes that sometimes law enforcement requires the individual's PHI. For example, medical records crucial to the investigation and prosecution of a crime. Medical records to identify victims of crime or disasters. Medical personnel reporting incidents of child abuse, neglect, or domestic violence to law enforcement. PHI may be released in certain situations involving deceased individuals. For example, PHI may be needed by coroners, medical examiners, and funeral directors, needed to facilitate organ donations or provided to law enforcement in the case of a death from a potential crime.
As we discussed, the release of health information outside of normal treatment, payment, and healthcare operations, TPO, must generally be authorized. But HIPAA does recognize exceptions. Can you identify the differences between examples that require authorization and those that do not? Hepatitis outbreak. Authorization not required. Disability verification. Authorization required. Participation in clinical trial. Authorization required. Release to drug company. Authorization required. Routine claim for payment. Authorization not required. Reporting domestic violence. Authorization not required. Congratulations on successfully completing the Managing Protected Health Information course. In this course, you were introduced to ways to determine if health information is individually identifiable and how to de-identify information so it's no longer considered protected, uses and disclosures in day-to-day business, verifying the identity of someone who requests PHI, minimum necessary disclosure, our duty to control the damage of an unauthorized release of health information, and the basic concept of an authorization, when you need one and those times when you don't.
Remember, as their caregivers, our patients trust us to keep their health and billing information confidential. This means we need to protect their information from anyone who doesn't have a reason to know it, even our own employees. Please review the specific policies and procedures that your organization has in place for protected health information. The individuals and companies who rely on our services expect that their information will be kept secure and protected. This is a good business practice, and now it's also the law.
Thanks for joining us today.
If you have any questions or concerns about information related to protecting health information, please contact your supervisor or your privacy officer.